Certainly, when we're talking about the whole settlement process, I don't think that the question of timing can be underestimated. Look, we all know that most matters, either litigate or non-litigated matters are going to get resolved in some way before you.
Good morning, everyone, and welcome. Today is August 1st, 2024, and this is the New Possibilities Hour, part of the Will Work for Food project, founded by Natalie Armstrong Motan. Every Thursday, Jean Lawler and I are delighted to host another episode for mediators, arbitrators, lawyers, and everyone who negotiates. As most people know by now, there's no charge for these great webinars. Rather, we ask people to contribute to a food bank if they like what they see. And our audiences have been so generous in the 4+ years since we began this series, contributing in honor of our great speakers. Every week, one of my favorite parts of the program is when we announce the running total of just how much our generous audiences have contributed. Natalie Armstrong Motan, would you please do the honors?
Oh, Jeff, I'm happy to do it. Mr. Levin gets to have bragging rights for the presenter that has on his presentation put us over the $600,000 mark for donations. The donations that we've been told about thus far now total $617.21. And we greatly appreciate all of our regular supporters and new viewers and new listeners in helping us to support food banks worldwide.
That is awesome. Thank you very much. And now we're going to have a wonderful presentation from Brad Levin talking about the role of personal counsel in settlement negotiations. It's all about the timing. Brad Levin is a shareholder in the firm of Levin, Sitkoff, Wanika, PC, with an emphasis in tort and commercial litigation, including insurance bad faith and insurance coverage disputes. Mr. Levin received his undergraduate degree from Stanford University with distinction. He was elected to Phi Beta Kappa. He graduated from the University of California Hastings College of the Law, now known as University of California College of the Law, San Francisco, where he served as editor-in-chief of the Hastings Constitutional Law Quarterly. He's a member of the California and Colorado bars. He's a past president of the Colorado Bar Association Insurance Committee and is a Colorado Bar Foundation Fellow and ABA American Bar Foundation Fellow. He serves on the Colorado Supreme Court Committee on Civil Jury Instructions, the Colorado Supreme Court Committee on Rules of Civil Procedure, and the Colorado Lawyers Committee Board of Directors, and he was a member of the Colorado State Commission on Judicial Performance, which he chaired from 2012 through 2015. Mr. Levin has also served as chair of the Mountain States Regional Board of the Anti-Defamation League of B'nai B'rith. He's on that organization's National Commission and chaired its National Litigation Oversight Committee. In addition, Mr. Levin is on the board of directors of National Jewish Health. He's received the Colorado Trial Lawyers Association Kenneth N. Kripke Lifetime Achievement Award in 2015. He's on Band 1 in Chambers for Colorado insurance litigation. He's been recognized in Colorado Super Lawyers as one of the top 10 lawyers in Colorado for many years running, and is one of the top 50, now top 100 lawyers in Colorado for many years running as well. Brad Levin, we're very much looking forward to your discussion with us. Please tell us a little bit about the food bank to which you would like people to contribute if they're able.
Sure.
And then on with the presentation.
Sure.
The floor is yours.
Thanks, Jeff. I appreciate it very much. First of all, I want to thank folks for you and Natalie for inviting me to participate. It's obviously a very, very worthy cause. I'm glad I was able to help to push us over the $600,000 mark here. food bank. So the organization is it's the Food Bank of the Rockies, and my understanding is that the Food Bank of the Rockies, which I guess last year served over 370,000 families. The geographic region, as I understand, is the largest in the country. It covers over 125,000 square miles. It includes Colorado, Wyoming, and obviously very, very worthy. A lot of challenges, the kind of challenges which I'm sure food banks all over the country are facing with increased costs for food items. And certainly, in terms of folks, we state of Colorado is a growing area, and certainly with an increased population and people, the needs are ever increasing. So certainly appreciate everything that this organization does, and certainly to the extent to which people can make contributions to Food Bank of the Rockies, that'd be great. So that said, what as Jeff mentioned, as far as the topic that I want to talk about this morning, has to do with negotiations and timing issues, but in particular having to do with the involvement of personal counsel, and how it is that personal counsel can really help to effectuate a resolution of the matter and do it in a manner, like I say, where it can sense whatever is the best timing for getting the best resolution. In other words, to be able to effectively use the settlement process as a risk management tool. As far as the presentation itself goes, like anything else, I don't have all the answers, and I know that there are going to be questions. I hope there are going to be questions, and certainly, Jeff, to the extent to which you want to, as far as assisting, as far as moderating, and so on, if there are matters that come up. I don't know that as far as the presentation itself, it's going to take a full hour to get through everything. And like I say, as I go through or afterwards, I really want to field whatever kinds of thoughts or questions that folks may have in order to facilitate, a better understanding about this particular topic. Certainly, when we're talking about the whole settlement process, I don't think that the question of timing can be underestimated. Look, we all know that most matters, either litigate or non-litigated matters, are going to get resolved in some way. Before you go all the way to a trial. And certainly I know that from my firm's perspective, I think that I am doing the best job that I can for my client if we resolve 100% of our cases. It's not that there's a necessary defeat if we have to go to trial. Some cases have to try, but certainly, the aim here is to try to resolve matters, to do it outside the context of having a court or a jury trial, because, for all the obvious reasons, you're talking about all the uncertainties that are going to be attached to going through the trial process. You have the finality, everything that I'm sure that other speakers, that Jeff through his mediation process that he's promoting, we really want to get things resolved. But the timing issues really are critical. And again, part and parcel of this, and what I really sort of want to focus on, has to do with personal counsel. As Jeff mentioned, my practice is one which involves largely representing policyholders when they have insurance-related disputes. It involves a whole gamut as far as who those policyholders are. It's everything from individuals up to small businesses, large companies, whoever it is who might have some kinds of issues, disputes with respect to insurance carriers. And as far as the types of insurance that we handle, again, it's the whole gamut. It's everything from, if you're talking about individual policies, general liability policies, first party, third party, health insurance, disability insurance, the whole gamut, if you will, of different types of insurance. As part of my practice, I am, from time to time, asked to serve as personal counsel. on behalf of an individual or a company that is either, it's most typically going to be in a litigation setting, but there are times that we have been retained to help out even in a pre-litigation context. So just as far as from a definitional standpoint, when we're talking about personal counsel, we're talking about in those instances where you've got a matter in which there is a claim of some type, and most typically it is going to be in the context of litigation. And it's going to be in a circumstance where, again, we're talking about in the most general sense, the most typical sense, where there's an insurance company is involved. An insurance company is affording a defense with respect to the claim. So it's most often going to be in what's a third-party context. In other words, where there's a party that's being sued on a liability type of claim. And where, for whatever reason, and there can be a myriad of reasons involved, that the company or the individual, either on their own or through the recommendation of the retained counsel, who's been retained by the insurance carrier, wants to have their own independent personal counsel to assist them. And again, there can be a number of different circumstances as to why it is that may be the case. Again, we're going to talk about just from a very general standpoint, which is that if you have a circumstance where an insurance company is defending under a reservation of rights, and that is in this day and age in particular, most often the case, that they'll send out, if they're going to afford a defense, they're going to retain counsel to defend the insured, that they're going to have, there's going to be a reservation of rights letter with respect to certain coverage issues under the policy. And because of the reservation of rights, it may be recommended by the defense counsel, or it could be, again, either the individual or the company who's involved, who's a defendant in the lawsuit, may feel as though they really want to have somebody who is going to be independent. And again, the reason for the independence is that often when you have retained counsel, that retained counsel most often is going to be somebody who is a panel counsel for the insurance company. They are retained by that insurance company to defend its insureds more than once. It could be, it could be 10%, 20%, some percentage of their business is afforded to them by that insurance company. And as a consequence of that, it creates certain conflicts. We know that in most jurisdictions, certainly in mine, in California, you have ethics opinions that deal with this, what's called a tripartite relationship among the insured who's being sued, the retained counsel, and the insurance company. There's this tripartite relationship, and states have various rules, ethical opinions about this as to where the loyalties lie, if you will, as between the retained counsel and the insurance company and the insured. Certainly in the state of Colorado, for example, it's absolutely clear that the primary responsibility of loyalty and of if there's any kind of uncertainty as far as again a conflict between the insurance company and the insured, that the retained counsel needs to favor their client. I mean, that's their fiduciary obligation is towards the client, even though they're being paid for by the insurance company. That being said, often the defense counsel will recognize, and they should recognize, that because of the fact that they are being paid for by the insurance company and there's these potential conflicts, that they can get involved with coverage issues, for example, and that's something which they will, if there are some pronounced coverage issues, that's something where they will recommend to the insured client that they may want to retain personal counsel to advise them with respect to any kinds of issues, and to basically to represent their interests. And it could also, it's not just coverage issues per se, but that because of, and this is another very typical circumstance, it may very well be that depending upon the nature of the claim, how serious the amounts that are being sought by the claimant, by the plaintiff are, that those amounts will be in excess of the policy limits that are available. And again, that presents a potential, it's a potential conflict, if you will, and it's one in which that the retained counsel doesn't have the same ability to, in the vernacular, to pound on the insurance carrier to get the matter resolved. In other words, where you have an excess exposure, that means that to the extent to which there is a possibility that a verdict and a judgment will be in excess of the policy limits, that means that the individual, the company who's insured, is going to be exposed to that extent. And when I say exposed, it means that if they're more than the policy limits that are the outcome of the case, that means that the insured will potentially have to go into their own pocket, go into their own assets in order to pay off on a judgment. So that, again, that's an exposure which it's something which part of the entire relationship, it's something which the personal counsel needs to sort of step in and deal with and protect the insured. And so again, that's something that retained counsel can't do. So the role of personal counsel is very, very, very important. And what I can tell you that, as I've said, we often, our law firm will get retained to serve as personal counsel on behalf of insureds to deal with these kinds of issues, the coverage issues or the excess exposure issues and so on. As personal counsel, though, we find that we can act in a very important role that, again, the retained counsel can't. And very frankly, someone like Jeff, someone who is in the mediator role, isn't able to do either. In other words, the mediator is not in a position to be able to control the timing, if you will. In other words, it's going to be a matter where the parties come to the mediator and say, hey, we want to try to get this thing resolved, and we'd like you to do it. But it's until the mediator gets contacted and gets hired and gets involved with the matter that they are then able to jump into the fray and deal with the issues to try to get the matter resolved on behalf of the parties. If you're personal counsel, you have potential ability to be able to have control over the entire process. When I say the process, we're talking about the separate process of resolution, so that the personal counsel can be a tremendous aid if it's a mediated matter, or even if it's not a mediator, if it's not a mediation, to try to get the matter resolved. Timing is all important in that regard, because you want to sort of find whatever that sweet spot is in the course of the litigation. And again, we're assuming that we have litigation, or even if it's pre-litigation, what is that soft spot where the parties are going to be most able to get the matter resolved? So in that regard, the hiring of personal counsel can take place at any step along the way. It may be, again, on a pre-litigation basis. It could be at the point at which the insurance company has sent out that reservation of rights letter and has retained counsel, but there are some very strong reservations. In other words, when I say strong reservations, that there are some pretty tricky coverage issues, and that those coverage issues may make the insurance company reluctant to put money on the table, if you will, at the end of the day, to try to get the thing resolved without, for example, without looking to the insured to put in some money as well, in recognition of the fact that there are these serious coverage issues. So it may be at the stage when you send out that reservation of rights letter, or, as I say, very typically, insurance company, because of the nature of the claims, the amount of damages that are being sought by the plaintiff or claimant, they will say, hey, you've got this excess exposure here, and they will advise the insured, you have the right to be able to retain your own personal counsel at your own expense. And that's, part and parcel of this. When we're talking about personal counsel, that's going to be an instance where, again, most often it'll be the insured who will have to pay for the personal counsel's the expense of hiring them. Now, that being said, we know that, for example, in California and some other jurisdictions, they have under the what's called Cummins Counsel, because of the Cummins case that was decided a few decades ago in California, and they now have a statute there that says that if you have the insurance company that is defending under reservation of rights, there is the possibility that the insured can have separate counsel, and that separate counsel will have to be paid for by the insurance company for their services. That's not true in all jurisdictions. It's certainly not true in the state of Colorado, for example. So you're often looking at the insured having to, again, on their own dime, have to hire personal counsel. But again, the role of personal counsel can be very, very important, very valuable in trying to effectuate that type of a settlement on behalf of the insured. The recommendation as far as finding personal counsel, it can come from the lawyers, right? And often we have where retained counsel has given 2 or 3 names of potential lawyers to act as personal counsel on behalf of the insured. We then get contacted by the insured about potentially acting in that role. Sometimes, again, independently of the retained counsel, folks get our name and they say, hey, is this something that you can or would be willing to do, is to act as personal counsel. So it can happen, as I say, at the point right the outset of the case, at the point at which the insurance company has sent out a reservation of rights letter, sent out an excess letter. There are times that we are brought in only at the point at which, you've got, it's become clear because of the course of the litigation, where at the beginning it looked as though, hey, the insurance company, the insurance money is going to be sufficient in order to get this thing resolved. It should get resolved, relatively quickly, and things don't meet that expectation. And so you've got, because of whatever claims that are out there, whatever discovery has been adduced, it's determined, the defense counsel says, oh, wait a minute, there's a lot more at stake here, more than the policy limits. And at that point, they recommend to the insured to get personal counsel. It may very well be, and we sometimes are brought in just right on the cusp of a settlement conference. Where again, the retained counsel says, hey, I think that personal counsel needs to be involved because they're having conversations, for example, with the claim adjusters. And they may not have realized that those coverage issues really were going to become so pronounced that the retained counsel realizes that the insurance company is going to balk at paying any kind of real monies because they got these strong reservation of rights, because these coverage issues and so on, and therefore they feel as though it really behooves the insured who's being sued to get personal counsel involved. And there are times, frankly, where it's on the eve of trial, where there's a lot of vigorous efforts to try to get things resolved. And again, often it's retained counsel who says, hey, I think it's really important to get personal counsel involved. But so again, timing issues, again, can vary depending upon when it is that you're retained as personal counsel. But if you're acting as personal counsel, you have someone involved, and you are, there during the spans of the litigation. If it's there when you have the ability to be able to sort of take hold of the matter, right from the outset, very frankly, that can be ideal. And, again, you have to be very mindful. I am as personal counsel. I make it clear up front to my clients that they're having to come out of pocket. And, they often will ask me, the projections, how much is it going to cost for me to serve in personal counsel role? And what I often tell them is that it's really dependent upon, what the course of things go. If it's a matter in terms of my writing a letter or two to the insurance company, if it's a matter of writing what's called a hammer letter, if that's all it is because the litigation has gone on to the point that what remains to be done is simply you're going into a settlement conference. There's the potential for an excess exposure. It's important that you get the matter resolved within the policy limits in order to protect the insured from exposure beyond those limits. That maybe all I'm going to be doing is writing a letter to remind the insurance carrier that they really need to, if they have the opportunity to settle within the policy limits, that's what they need to do in order to protect the insured. And I may or may not be attending the settlement conference. I may be on hold. I may be on standby if there are any issues that come up. But often I will actually attend the settlement conference to aid, if you will, in terms of trying to get the thing done. So again, the role of personal counsel can vary in a lot of different respects. But one of the things which, again, the role of the counsel is very, very distinct. And that's why we can very often work very hand in glove with someone like Jeff as far as, their efforts to try to get the matter resolved. The ultimate goal of the personal counsel is to help to effectuate a resolution. And in that sense, the role of the defense counsel, in my mind, is really different. I mean, obviously, they do have those fiduciary responsibilities to their client, and they know that at the end of the day, what they're supposed to do and what they need to do is to effectuate some kind of resolution of the matter, hopefully to do it without having to go to a trial, but to try to get a resolution which is going to be most favorable to their client. So, of course, what the retained counsel is doing, they're working the case up, right? I mean, they're defending the case. They're the ones who are going to be, taking the depositions, doing the discovery, whatever it is, whatever the pretrial proceedings consist of. So, as personal counsel, you are looking to them for information. And that's one of the keys that I really want to just sort of hone in on today. And that has to do with information, is that you've got the insured's counsel, the retained counsel, who is gathering information to assist in the defense of the case on behalf of the client. As personal counsel, what you want to do is to do everything that you can to gather, again, information in order to help to effectuate a resolution on behalf of your client. And, information is power. It just simply is. And as personal counsel, you have the ability to gather information in a manner that sometimes the retained counsel is unable to. And what I mean by that is that I find myself as personal counsel that I can have conversations with, for example, the plaintiff's lawyer that defense counsel, retained counsel can't have. And when I say that they can't have it, there's obviously a certain wariness, there's a certain amount of obviously advocacy, maybe adversity going on between the defense counsel and the plaintiff's counsel. And often, there's again a sort of wariness, right? If you've got somebody who does insurance defense work all the time, and you've got a plaintiff's lawyer who's looking at them, and again, they're on the opposite side of the V, they kind of look askance at them, and they feel as though, hey, their interests are really just to try to continue this litigation and make things more difficult and fight my client and so on. Whereas I can approach the plaintiff's counsel, first of all, because my practice largely involves representation of policyholders. I'm typically, as far as my practice, I'm on the plaintiff's side. And I often have a really close relationship with the plaintiff's lawyer. I know them. I work with them all the time. So there's a certain trust that's already there, okay, because of that. But the other thing is that what I'm able to do is to talk to the plaintiff's lawyer and say, look, I'm everybody's friend. I am your best friend because my job, first of all, I mean, my fiduciary, my obligations are to my client, who's the defendant in the case. Okay. So you know that right up front, that's where my obligations lie. But that being said, my only responsibility here is to try to get this thing settled. And whatever that amount is, doesn't matter to me, so long as the money's coming from the insurance company, right? So long as you're not looking at my client, either you or the insurance company is not looking at my client to contribute to pay money on this claim. I mean, that's the ideal. That's what my goal is here. So in order to effectuate that goal, I'm your friend. I'm your best ally. And so I need you, and again, it's typically someone who I know, I need you to help me to try to go to the insurance carrier, ultimately with information in order to effectuate the settlement. So what I'm doing is I'm sort of, in that sense, just like Jeff does as a mediator, I am working both sides of the fence. And I say, you've got, in a sense, it's not an enemy per se, but yeah, it really has to do with, I really am working on your behalf, even though, again, my responsibilities are my client, but I'm helping you to effectuate a resolution as well. And make sure it's out of the insurance company's pocket. So in order to do that, I am, first of all, and again, it has everything to do with in terms of timing issues. What I want to do is I want to talk to retained counsel. I want to get information from retained counsel. I want to understand for them, what are you telling the insurance carrier? What does your evaluation look like? Provide me, because, again, we're all on the same side. So, there's no question about privilege or anything else, right? Because we represent the same client. Provide me with, whatever kinds of evaluation letters that you are giving to the insurance company. Provide me with your assessments. What are your budgets? Okay, because that becomes a really important issue, as we all know, that as litigation goes on, the insurance company's having to spend more money. So again, in terms of, from a timing standpoint, if we, and when I say we, both, in conjunction with retained counsel, if I'm able to go to the insurance company and say, hey, now's the right time to strike, to try to get this done, to hire a mediator, to try to get this matter resolved before you end up having to expend a lot more money, because I've got the budget and it says that in order for you to go forward and hire expert witnesses and to do the other pretrial proceedings and to go to a trial, it's going to cost you this much more money. So I'd like to know what that budget is so that we can, use that as leverage with the insurance company to try to get the matter resolved and to do it at an appropriate time. So it's a matter, what are you telling the insurance company about exposures? What about in terms of the timing? And what is the future? What additional work has to be done in order to get this done? And what are you hoping to achieve through that, right? So what information are you trying to gather so that, I as personal counsel can have access to that same information, again, to assist in trying to resolve things, which is the only goal that I have on behalf of my client. And then I want to have a better understanding from them. Hey, this claim adjuster who you're dealing with, tell me about the claim adjuster, right? And again, in some senses, no different than something which a mediator like Jeff is going to ask, them as well. But I want to understand that too, because I don't know that claim adjuster. I might, not very likely, but but if it's a personality that I need to know about, what are their reservations? What are their concerns? What's their personality? Are they somebody who's amenable? Are they somebody who's going to be, is really going to fight hard in terms of trying to get the case settled? Are they somebody who's just going to stand there and say, we're not, this is all we're going to do, and we're not going to, we got to take this case to trial because of X, Y, or Z? Or there's someone who's going to be more amenable? What's their personality? To have a better understanding about what the managerial supervisory, what the ladder looks like, right? In other words, who else is involved in overseeing the claim? Who has to go where in order to get additional authority? Do they have claim committee meetings in order to evaluate cases? I want to have a better understanding about how the insurance company works internally when it comes to evaluating a case and coming up with amounts that they're willing to authorize for settlement purposes. And then what sort of gets added on, and it becomes more tricky, and this is where, again, personal counsel can be incredibly valuable, is when you have multiple insurance companies that are involved, where you have a claim which against multiple defendants, or where a particular defendant, or where my client has got different policies of different types, or if there's a primary and excess policy, or if there's a professional liability policy for certain things and a general liability policy. So what is the interplay among those various insurance carriers? What do those policies say? And of course, that's part of it. One of the first things I need to do is look at the policies and see, what it is that they provide, where the coverage issues are, and so on. But also to get an understanding from retained counsel or counsels. I mean, because, often we see this, for example, in construction litigation, where the insurance companies will have more than one lawyer who's representing a particular insurer because, a primary carrier likes a certain set of lawyers, and then there's an excess carrier that has, their law firm that they like. Or again, if you've got somebody who does professional liability stuff and somebody else who does the more general liability stuff and so on. So you may have more than one lawyer who's representing your client. And you want to just work things out with them. You want to understand exactly, get a good feeling from them as to, what the processes are internally within the insurance carriers for you to do your job. And then I can talk to the, plaintiff's lawyer and have conversations with them. Like I say, there's a certain level, if you will, I hope, of trust for them to understand, that, and plaintiff's lawyers typically will get that. They understand that your job, it really is to work and to help them, help their client get the matter resolved. So it's a matter in terms of talking to them and finding out, what their client's expectations are, what their expectations are, what they think is best in terms of from a timing perspective. And also, and I'll talk with them about, listen, I'm absolutely unabashed, unafraid about having these conversations, although I'd like to hear what other folks think about this, which is that if there are some coverage issues, look, one of the frustrations, which that sometimes if I'm serving as personal counsel, is that the plaintiff and their lawyer, they are the masters, if you will, of their pleadings. And in Colorado, California, most jurisdictions, the question of whether or not there's going to be a defense obligation right from the get-go, and going beyond that in terms of whether or not there's coverage, is often going to be dictated by what the complaint says and how the case is being prosecuted. In other words, what are the theories of recovery? What are the claims that are being made? And depending upon what those claims are, it can have a profound effect on coverage. And I will have conversations and have had conversations with plaintiffs' lawyers and said, you may, and they will ask me about it. And sometimes I'll volunteer. You may want to think about amending your complaint, adding some theories, dropping some things, okay, in order to deal with coverage issues. Because, again, what I'm going to tell them is you're going to have a heck of a time if you're trying to prosecute this case, and if you don't have insurance coverage, you can get the biggest judgment in the world, but collecting on that judgment is going to be really, really, really tough. And so the way to deal with that issue is to prosecute your case, to have your complaint, to have your claims basically pled into coverage. So I can have those conversations with the plaintiff's lawyer. I also ultimately can play another, quite frankly, very important role. And this is skipping a little bit of ahead on what role personal counsel can play. But that is that if there are problems as far as getting a case resolved, either because of the coverage issues or because you've gone to a settlement conference and the insurance company just simply isn't playing ball and they're not doing what they should. I can and will have conversations about the potential for doing an assignment of rights. And that's, again, a role that personal counsel can play that that the retained counsel can't. And that is the possibility if if the insurance company is not acting appropriately, if they are either because of their refusal, failure to defend on certain claims, or and very frankly, if right from the get-go, if they don't want to defend at all, that's a whole other ball game where you basically are going to approach the plaintiff's counsel right from the get-go and say, hey, rather than go after my client who doesn't have the money to be able to defend this case, doesn't have the wherewithal to be able to pay any kind of verdict or judgment, I think that I'm going to convince you that the failure to defend is wrongful. They shouldn't have been defending this case, that the duty to defend is a broad one. They've violated that. And so what I want to do is talk to you about assigning the rights against the insurance carrier rather than going after my client. But again, that's a conversation that can be had at other points during the course of the litigation. If you go through a mediation process or any kind of settlement process, and the insurance company just simply is not doing what they should in terms of putting up the monies to settle the case, I will approach, and I can approach, the plaintiff's lawyer and say, hey, listen, I've got a better deal for you. Rather than you're expending the time, the energy, going through an entire trial, is to talk to you about the potential of a pre-judgment, a pre-trial assignment of rights, so that you're basically trading out your claim against the insured for a claim against the insurance company. Jurisdictions, it's a whole other conversation about whether or not you can do this on a pre-trial basis. Different rules in different states, and they've changed. California used to have a certain set of rules that has changed over the course of time. Colorado allows for both pre-judgment as well as post-judgment assignments of rights. But that's, again, a role ultimately that a personal counsel can play that a retained counsel can't. So again, a myriad of abilities that you have as personal counsel to try to resolve a case. So getting back, as I say, we've talked about talking to the defense lawyer, getting the information that you can about, getting a good feel about what the insurance company is being told, what they know about the case. Talking to the plaintiff's lawyer, trying to understand and have them assist in the process as far as trying to get the matter resolved in a way that's favorable to their client. And then obviously having conversations with your client, right? And those conversations are going to be all about, wanting to understand what their goals are. Very frankly, there's always resistance, right? I mean, no one likes to get sued. There's often a lot of emotions that are involved with that. And you have to sort of do what you can to sort of manage that and to help them through the entire process to understand that's why you bought insurance in the first place, right? And it's unfortunate you have to pay your lawyer in order to help you out here. But I can assist in this process ultimately to get your insurance company to step up and try to get this matter resolved for you. And so once you get all that information, you as personal counsel can then be in a position to interact with the insurance company. And I will tell you, again, it's been myriad in terms of I've sometimes had access, the ability where a claim adjuster is willing to talk to me on the phone, either prior to a mediation, well before that, understand what my role is, but where I can talk to them after I've gotten all this information. It may be just simply a matter of corresponding with them. And of course, that correspondence can, it's very, very important particularly if there's a possibility for excess exposure. It may be that you're writing these what are called hammer letters in order to create, if you will, a paper trail that may be useful in a case if you ultimately have to prosecute a bad faith case against the insurance company because that there's been an excess judgment against your insured. and there's a potential for a bad faith case, that you want to, again, have correspondence, a paper trail that reflects your efforts to try to get the insurance company to get the matter resolved without having to go to trial and exposing your client. So what you do is that you either through correspondence with the carrier, or through direct communications, to be able to communicate with the insurance company about the various issues and about the timing, and basically trying to convince them that now's the right time. Let's, before you spend all that money, there's a soft spot right now for us to get this thing done, where the plaintiff's lawyer, before things, get elevated and escalated, and they go out and, once they start hiring expert witnesses, now, their costs have ratcheted up and it's made things more difficult, or where there's going to be more contention, or where's the possibility, which would really be bad for your client, okay, is if, there's some really, some bad stuff out there that maybe the plaintiff's lawyer doesn't know about, but once they find out about, could lead to the possibility of amending complaint to include punitive damages, right? And the problem with punitive damages is that under most policies, punitive damages aren't covered. So that is in and of itself an excess exposure to your client. And that's, be really bad to have that kind of exposure out there. So you can try to stem that from happening by, again, regulating the timing of the mediation and settlement efforts, so as to avoid that possibility of there being, like I say, punitive damage exposure or any other type of exposure, because you can't get the matter resolved. So at the end of the day, I guess, what I'm sort of urging here is that personal counsel can play an incredibly important role in conjunction with the mediator, but even without a mediator, even in advance of the time that you're going to have mediation, because you have the ability, once you've been retained, to be able to help to control that timing, to control the flow of information, and again, cannot emphasize or underemphasize the importance of information in that process, and be sort of a conduit, just like the mediator can serve as a conduit, that as personal counsel, you can be an important conduit for the flow of information. Again, realizing, that you have attorney-client, you can't be divulging to plaintiff's counsel attorney-client communications, right? You can't do that. But you have the ability, because you are talking to the plaintiff's lawyer and you're talking to the retained counsel, to convey to the insurance company adjuster what your overall sense is, and to talk to the retained counsel and say, hey, listen, and to work in conjunction with them. I've got cases that I'm working on right now that we basically have taken sort of the lead along with retained counsel in dealing with the plaintiff's lawyer to try to get the matter resolved through the efforts of a mediator. But we're sort of all working in conjunction and talking with the plaintiff's counsel about how it is that we can get this done. And in that regard, I'm serving in a role, and the retained counsel is serving in a role, because they're communicating directly with the insurance company, but we all have that same goal in mind, which ultimately is to get the case settled. So I guess to sum up, and I know we're reaching the point at which, if there are questions that folks have, I'd be glad to field them, to talk with any questions or thoughts that you might have. But at the end of the day, I again cannot overemphasize the importance role that timing plays as far as trying to get cases settled, whatever the matter is, or like I say, could even be on a pre-litigation basis. It may not be a case, it may just simply be a claim. And again, you can sort of stem the tide, convince everybody that it doesn't make any sense to go to litigation because of all the costs and the differences, because once a lawsuit gets filed, the next opportunity to talk settlement may be, months down the road, after everybody has gone to their corners and then done their disclosures and had some depositions and so on. If we can avoid the litigation in the first place, that really is ideal. So timing is very, very important. And the role of personal counsel in terms of trying to effectuate that, in terms of trying to control the timing, again, I don't think that can be underemphasized or overemphasized, I should say. That being said, I don't know if anybody has any thoughts, questions before we wind up.
Yes, Brad, thank you. Your insights born of so many years of experience. There's no other way to get those kinds of insights. Thank you very much for sharing so generously of your thoughts. Well, I have a few questions. Let
Yeah.
me ask you here. You talked about sometimes you work with people with whom you've worked for a long time and you develop a lot of trust with them when you're dealing with, for example, a lawyer for a plaintiff who's suing your client. And there must be other times when you're dealing with people for the first time, or perhaps plaintiffs' lawyers who are not as experienced in dealing with an independent lawyer for a policyholder slash defendant. What do you do to establish trust in that circumstance where a plaintiff's lawyer say, wait a second, you represent the defendant and you say you're on my side? What's up with that? How do you deal with that, Brad?
That's Jeff. I appreciate it. That's really a good question. It's more difficult. I will just tell you, because you hit the nail on the head. It's that last thing. There's just this sort of this sense of mistrust, and as you mentioned, I'm involved with the Colorado Trial Lawyers Association, and who represents generally are going to be representing plaintiffs and so on. And everybody just, there's sometimes a tendency to sort of to vilify the other side. And one thing that I've always talked about to the Colorado Trial Lawyers Association folks and the folks on the defense side, there's no reason for that, right? I mean, in other words, sometimes, obviously you have clients to represent, you want to be vigorous in that representation, but sometimes, there's more to be done with the honey, right? Rather than the vinegar. And in that sense, and because it goes to what you're saying, Jeff, is that if somebody really is not quite as experienced, right, hasn't been practicing that long, doesn't know what the role of personal counsel can be, they sometimes have that natural adversity, right? They're already, and it's like, what's that about? You're representing them. I don't understand, Brad. Explain that to me. And Jeff, the answer is it's just an educational process. It's just really a matter of my spending a little more time than I, often, if someone's experienced, they know me, they get it, like they got it. It really is just a matter of spending the time and saying, hey, listen, I get it. I understand why there's this natural, hesitation here. But let me sort of walk you through a bit. I often will say, hey, maybe, suggest a couple of other folks, maybe some mentors of them, people who are either in their law firm, people who they know, who I know that they, we have common people we know within the Colorado Trial Lawyers Association for them to talk to, for them to just sort of ease their concerns. But yeah, that happens, and it's just takes a little bit more time for them to get comfortable.
Okay, now let's push the other end of the scale of cooperation. And we know that insurance policyholders have certain duties to the insurance carriers. There's a duty of cooperation, and there are other duties as well. So you talked about whispering perhaps into a plaintiff's ear with respect to the pleadings. So if you have a little sidebar chat with a plaintiff's lawyer and say, look, my friend, you might consider adding a cause of action for negligence or defamation into what is essentially a breach of contract case to trigger coverage under a general liability policy. Or you might consider ditching the punitive damages allegation or the intentional misconduct fraud allegation out of what is essentially a negligence case to ditch a reservation of rights. What is your sense of when you might go too far in terms of the policyholder's duties toward the insurance carrier?
Yeah, appreciate the question a lot. So let's separate the two things out. In the latter circumstance where I'm suggesting that they cut claims out, right? They ditch the claims that potentially are going to be non-covered claims, that the punitive damage, that's easy, right? And when I say that's easy, there's not going to be any kinds of issues, right? Because you're basically narrowing down the scope of any potential exposure to the insured, right? So that's easy and really not, from my perspective, at all problematic. You've absolutely identified the other side of it, right? And it can be tricky. It depends upon what it is that you're talking about. In other words, and it runs the gamut. As you say, you got to reach the contract case. Next thing you're doing is you're saying, oh, okay, now you need to sue my client for defamation and for negligence and so on, right? That's trickier, okay? Because you're 100% right that there is that cooperation provision. And at the same time, I'm being very mindful that I've got the client to represent. And I need to do things within the bounds of not doing anything that's going to be violative of the insurance policy, that the insurance company is not going to say you violated your obligations, and particularly, as you say, Jeff, the cooperation obligation. I'm going to be most mindful of what's the best thing for me to do in order to protect my client. So it is tricky. I'd say that at the most, I'd say as a rule of thumb, so long as what it is that I'm talking about is not going to increase the exposure by way of monetary exposure. In other words, it's not going to expand the the amount of, as I say, monetary damages, exposure, and so on. If it's just simply going to be, if you will, an adjustment in terms of what the theories of liability are, that is a general matter. I think that then you're going to be okay. The one thing you don't want to do is do something that is going to make the monetary exposure, basically suggest to the plaintiff's lawyer, have you thought about this theory that's going to, by the way, will increase the monetary, now you got a defamation claim and you've got a whole host of new stuff with a whole host of new damages and, treble damages and whatever it is. And now what you've done is you've increased the exposure to the client and ergo the insurance company. That could be really problematic. But if it's a matter in terms of adjusting what the approach, what the theories of liability are that are more consistent with the insurance coverage, I think that that's going to be generally is going to be okay. But you need to be, you got to be mindful. You got to be careful about that.
Thank you. Now, one last question, Brad. When the policyholder is a big Fortune 500 company, they've got a risk management department and they know all about when to call somebody like you. Smaller business enterprises, family-owned businesses, entrepreneurial businesses, they may be big companies in terms of their revenues, but they may not have the sophisticated infrastructure of, say, a Fortune 500 company. And they have an outside general counsel, perhaps a corporate lawyer who's a corporate generalist, and that lawyer may feel comfortable at a certain point dealing with an insurance company. And at a certain point, it may cross the line to where they really need a specialist who like someone like you, who really knows the ins and outs of things. What advice would you have to outside general counsel, corporate lawyers for entrepreneurial mid-sized businesses as to when it hits that point when, if this happens, you really ought to consider the wisdom of getting a specialist. Up till now, maybe you could have handled it yourself, but now maybe think differently. What rings that bell?
Yeah, I appreciate Jeff. And it obviously becomes sort of an issue because again, you're now asking the insurance company if they've got outside counsel, that's somebody who is, most typically is going to be on their payroll, that they're paying them. You're now saying that you're the company. Well, there are two aspects to it. One, sometimes you're dealing with with their their GC who may who may feel as though, they want to show their worth, that they're able to, to do a myriad of things, to show that, there's value to that company with having a general counsel or somebody who's going to be, as you say, sometimes on retainer or whatever it is. So sometimes you're dealing with that kind of an issue. I think, though, for the most part, my advice is, the insurance very frankly, there are a lot of complexities that are involved. There really are. It's really not something for the inexperienced or uninitiated. My advice is that if there's any kind of issue at all, unless the insurance company has gone out and said we're going to defend this, we're going to take care of this, and it looks like they're going to do it, they're going to do it with their own money, they're going to do it quickly, it's going to, and there's not going to be any kind of problems. If there's any sign whatsoever that the claim has got any complications, that the insurance company's not just going to step up right away and make the problem go away, once there's that kind of signal to the general counsel or to even outside counsel who just does the work for this company, my advice to them is to, the better part of valor is to, find somebody, my firm, another firm that does this kind of work, get somebody on board relatively quickly, at least to consult with. I mean, and again, I do that all the time. I'll get calls from them and they'll say, hey, Brad, what about this, that, and the other thing? And they might, pen letters and then send me the letters for me to look at and to give my input on and so on. So I often will be in that position. I often do work with, with general counsel, whatever, along the way to sort of help and guide them. But these insurance issues can be really, really tricky. And it's the kind of thing where corporate counsel very often, they really are very steeped in their client's business, right? But that client's business doesn't involve, insurance issues. And knowing what those insurance issues are. So my advice to them is, if there's any sign, anything whatsoever, try to get somebody who understands this stuff involved pretty quickly.
Yes, and I can tell you from the mediator's chair, so many times when there's a hot reservation of rights and a serious coverage issue, when qualified, experienced, policyholder side coverage counsel, someone like you, shows up at the mediation, it is just fantastic, because then the issues are getting fully vetted as between the policyholder and the carrier, and appropriate amounts of money are being raised to settle a case, and they're frankly coming from the appropriate pockets. So when the policyholder side insurance coverage counsel shows up at a mediation, it can just make things go so much better and so much more smoothly. Brad Levin, thank you so much for a wonderful presentation. We hope that people are motivated to contribute in your honor to the Food Bank of the Rockies. That's www.foodbankrockies.org, www.foodbankrockies.org. Brad Levin, on behalf of Natalie and Jean, myself, thank you so much. We are complete.
Thanks very much. I appreciate your having me.